This will be writing AIPRA compliant wills, which I think is a good sort of wrap up of everything that Professor Ross has been doing all day today, essentially. So again, please make sure to fill out your evaluation forms. They're important for us to really get a good feel for how well these sessions go and how they help you guys. This is an MCLE course, so if you are an attorney and you want credits at the end of the session, I'll have a sign-up sheet that you can use. And finally, because we are recording this, if you would please raise your hand if you have a question or something, and let me get to you with the mic, then it'll help everything. So, again, Casey Ross.
Thank you. Thanks. All right, so we're going to spend some time today talking about writing AIPRA compliant wills. And I know the slide says they're complaint wills, but they're actually compliant wills. So we're going to be complying, not complaining. And I want to just point out, I'm joined today by my colleague from Oklahoma City University School of Law, Lori Harless. She'll wave. She's in the green jacket. Those of you who have not seen her in the room earlier today, I just want you to know I'm going to embarrass her for a second. She got food poisoning right before we left Oklahoma City yesterday morning and has been ill for the entire time we've been here. And I'm very happy to see her powering through and here for our final session because she has had a rough time. So be nice to her if you happen by her. Okay, so I'm the director of our American Indian Wills Clinic at Oklahoma City University School of Law. And we work with law students to teach them how to practice law before they graduate. It's just like any other kind of profession, right? So like if you're a doctor, you have to do clinicals. If you're a nurse, you have to do clinicals. So in the legal profession, we also want students to do clinicals so that they actually have some experience working with clients and practicing law before they get their license and start practicing on their own, because that's how they really learn the best practices. So our law students provide estate planning services to American Indians in the state of Oklahoma who own an interest in trust, 5 tribes restricted or Osage property, and those students serve as attorneys under the supervision of a licensed attorney faculty member to learn how to do this work. And I always tell my law students, if you can write a will that disposes of Indian land, you can write any other will on the face of the planet, because they are definitely the more complex types of wills that we deal with in the law. So we're going to talk just a little bit today about how to make sure that the wills that you write are AIPRA compliant. Before we get started, how many of you are in the business of writing wills for Indian trust beneficiaries? Anybody here? Has anyone ever done one, written one? Okay. So interestingly, the Bureau of Indian Affairs used to offer a will writing program for beneficiaries, but they got out of the business of doing that. At some point, I think the department determined that there was liability potentially being created by having staff members to do this, but it wasn't attorneys. It was, just frontline staff employees who could work with individual trust beneficiaries when they came in to draft these wills. So I want to make a couple of disclaimers. Number one, in my opinion, okay, you don't have to be a lawyer to understand how to write a will. You don't have to be a lawyer, okay? But I want to caution you, all right? Individual states have laws about people practicing law without a license, giving legal advice without a license. So if you, in your capacity as a non-lawyer, wanted to write a will, I just want to caution you that there are laws against practicing law without a license that may impact your ability to do so. If you have a question about that, talk to a lawyer in your state. Talk to a licensed attorney in your state to get legal advice from that person about the breadth and the extent to which you could engage in that type of assistance for a person. However, I want to be very clear. There are ways for individuals to undertake writing their own wills, okay? And we'll talk a little bit about that here in just a bit. Okay, so we know from the American Indian Probate Reform Act, and we know from the regulations that have been promulgated in response to the passage of that act, that we've got this uniform probate code that applies to trust property. We've got a uniform probate process that applies to Indian land, and it's all easier and better than it was before the passage of AIPRA from a lot of different perspectives. So I want to talk today just kind of the nuts and bolts about what it takes to be able to make a will, okay? So any person who is 18 years of age or over and who has testamentary capacity can go ahead and write a will. I want to talk about what testamentary capacity is, okay? Because in law school, I teach wills, trusts, and estates, not in the Indian law context, just plain old wills, trusts, and estates. I teach it in law school. And we spend probably 2 weeks talking about testamentary capacity because there are all kinds of cases about it. It's all, kind of interesting. But the general rule is this. If you know what property you own and you know pretty much who it should go to, you have an idea of who you want to leave it to, that's the threshold for testamentary capacity. It's a very low threshold, okay? It doesn't require a whole lot other than do you know what property do you have and do you know who it should go to? That's really all it requires, okay? So any person who's over 18 with testamentary capacity can write a will. There are issues that impact whether a person has testamentary capacity that have nothing to do with whether they know what their property is and whether they know who should get it. For instance, if they're being like bossed around and told what to do in their will, that's a provision, that's a concept in the law called undue influence, where a person is, writing a will in favor of someone even though they don't really want to do that. They're doing it because they're being pressured to do it, right? So if a person's under undue influence, it affects whether or not they're going to be determined to have this testamentary capacity. Basically, they're not making decisions on their own. They're making decisions under duress, okay? So a couple of things can impact testamentary capacity, but for the most part, it's a very low threshold. Okay, so let's talk about the requirements for a valid will. And the citations that you're going to see in this presentation, these are on your jumps, but the citations are referencing the Code of Federal Regulations, where we see the regulations that were promulgated after the passage of the American Indian Probate Reform Act. So you can look at those. They're super easy to follow, and they're super helpful because they're actually written as if the reader is an individual trust beneficiary. So it's nice because it talks... all of the regulations are set forth as if that is the person who's reading them. So they're easy to follow and super user-friendly. So let's talk about a few things from the American Indian Probate Reform Act statute that give us some limitations and some ideas about what we need to be thinking through whenever we're writing a will for a client. Number one, in the wills clinic, we've done over 1,000 wills. Okay, we've been doing it for about 10 years now, and we have more clients than we can ever serve because we have a whole lot of clients who want their wills drafted as a result of AIPRA. They don't want their property to be distributed the way the intestate succession schematic in AIPRA would distribute their estate, so they come to us to write wills. I have clients come to me who want to leave their property to someone, and let's just say that a client comes in and says, I want to leave my property to my friend, right? If a client wants to leave property to someone, I have to go through the analysis to make sure that that someone is eligible to hold property in Indian status. Because if the person is not eligible to hold land in Indian status and my client leaves the property to that person, the property falls out of trust status and it's just fee status property, right? So if you want to maintain the trust status of your property, you can will it to a lineal descendant of yours, a co-owner in the same parcel, the tribe, or any Indian person. So when my client comes to me and says something like, I want to leave my property to my friend, I say, is your friend an American Indian? Is your friend a citizen of a federally recognized American Indian tribe? If the answer is no, my friend's non-native, then I tell the client, you can totally still leave your property to that non-native friend of yours, but just know that it's going to fall out of trust status and will be fee status, never be Indian land again. Now, and I'd say 100%, but just to be safe, I'll say 99%. 99% of the time when I tell my client that, hey, if you leave this property to a non-Indian person, it's going to fall out of trust status, they say, whoa, 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 never mind, I don't want to do that, right? I don't want my property to fall out of Indian status. But there is a fix that we'll talk about here in just a second. So if the client wants to leave property to someone who doesn't meet that definition of a person who's eligible to own land in Indian status, what the statute authorizes is actually the client can leave a life estate to anyone. And so long as the remainder after the life estate is over vests in someone who's eligible to hold land in Indian status, it will maintain its trust status throughout the duration, even while a non-native person has the life estate interest. Does that kind of make sense? So when my client comes to me and says, I want to give my property to my non-native friend, I say, if you give it to him outright, it's going to fall out of trust status, but we can do a life estate for that person's lifetime. And as long as after that person's lifetime expires, the property interest goes to a lineal descendant, a co-owner, the tribe, or any Indian person, it will maintain its trust status. So it's a fix. It kind of addresses that concern. Any questions about that? Yes. Oh, just one second. We're going to get a microphone over there. I'm sorry.
Slow.
When you give life estate to someone, what actually can they do with the land and say there was a home on it?
So if there's a home on the property, a life estate would allow the person who has the life estate to make use of the property and to live in the home, okay? And also to benefit from any income that's derived on the property during the duration of the life estate. But a life estate is not something that you're going to be able to sell. It's not something that you're going to be able to do a lot on. It's really just your ability to use the property, not to do much with it, okay? Any other questions?
Can the property pass to a lineal descendant who is not a tribal member or an Indian?
Right. So the interesting way that the statute treats that situation is because it recognizes, right, that our lineal descendants may very well not be citizens of our tribe, particularly in tribes with blood quantum requirements, right?
Yeah.
So the statute recognizes lineal descendants regardless of enrollment status, and the way that they define that eligibility is not tied to enrollment status. So as lineal descendants, they are eligible to hold property and trust status, even if they're not citizens of a tribe. Oh, we have a... Right. So you were here for the morning presentations, right? Okay. So we talked about the chart of consanguinity, right? And we talked about those relationships, the 2 degrees of consanguinity. That's where this falls into. So lineal descendants within 2 degrees are eligible to hold the land in Indian status. If they go past that 2nd degree, they're not. No, that's for purposes of the remainder, right?
So the land can't continue on in the lineal line if they get too watered down?
If they don't meet the blood quantum requirement.
Yeah, if they don't have, say, I mean, I'm enrollable, my kids will.
She probably needs a microphone.
Grandkids won't be, and maybe on after that. Could it continue to be passed down, or would one of these descendants have to kick it back to the tribe?
Definitely for the property ownership interest, it can go any place, right? But to own it in trust status, the individual who is going to be getting the property has to meet one of these definitions, either a lineal descendant of the testator, co-owner of the tribe, or any Indian person.
Okay, and so that lineal descendant would be 2 generations, a child or grandchild, and then.
I think we're confused on that one. I think the answer is yes, and Jim thinks it's no.
Ooh.
What did you think it was? Yes. He says 2 degrees. I think that's right, but it's been a long day and I could be wrong, so I'm going to reserve the right to correct that at some point. Is that fair enough?
Yeah.
I think it is 2 degrees. Jim says it's not. We'll get clarification on that.
We'll get clarification as she suggests. I'll look up the code,
Well, I have it right
but I'm pretty certain that it reflects 2 degrees without a will, but any lineal descendant with a will, I believe, and so I'll take some time while she continues with her presentation to look it up, but because to me it became one of those situations, okay, if I can give it to my great-grandchild who's not enrolled, they can't give it to anybody else except back to somebody who is enrolled.
So that and that language is not in the regs, it's in the statute, it's in AIPRA, so check there. Okay, we're going to get clarification. Sorry for the confusion. We've got differing opinions.
Wait.
Uh-oh. I like it when it's lively.
I know, man. People are running me.
She said this morning, I'm going to get my steps in. She sure is.
Thank you. Tim LaPointe, Bureau of Indian Affairs. Just my perspective is it's within 2 degrees. You can leave it to whomever you choose.
Yep.
Again, depending on the tribal code, if there is a tribal code. But you can leave it to whomever you choose, but it may go out of trust status.
Right. So the question on the table is whether it's that 2 degree rule for this or if it only applies in intestacy. So we'll get clarification on that and come back to it in just a minute. Does that sound good? Okay.
Got one more question.
Could you speak to, with regard to waste or without regard to waste?
Sure. So under, and please understand that my interpretation of it may not exactly mirror the interpretation or the application of it by the Bureau. It just may be different. But the without regard to waste under the law is a recognition that someone with a life estate should have the ability to use the property to the fullest extent of the user's rights that would have been given to a person who lawfully owned the property. So the without regard to waste is really a protection that says you can, to the extent that you have an ownership interest, you can exercise all of those same rights. So it really is trying to expand kind of what the person gets from a life estate. Not just you can be found there, but you can enjoy the property, you can utilize resources on the property, and you can benefit from any development or any income on the property. Why are you handing me this?
In general, subject to any with the devise,
Huh?
any
Yeah.
legal descendant.
Yeah. So it says any on the general devise of an interest in trust or restricted land. But keep in mind, just because that's what the statute says doesn't mean that that's how it's interpreted in application. And it's quite possible that when we're talking about a probate of a will going through the process at the Office of Hearings and Appeals, it's quite possible that they want to see that 2 degrees. It's possible. And until it's challenged, that's going to be what's happening. Jim busting out the legal research. I love it. Okay. All right. Any questions about that? It's really, it's really nice that there's this authorization for individuals to leave a life estate and to still make sure that the property is eligible to be held in trust status, right? You can, the times I see this the most for clients is when a client has a non-native spouse and the client wants to leave something to spouse but doesn't want the property to fall out of trust status. 99% of the time what my client will choose is to do a life estate in favor of a non-native surviving spouse with the remainder to the children who are eligible to hold land in trust status. So it's a good mechanism to make up for the fact that you don't want things falling out of trust, but you also don't want to leave your surviving spouse out. Okay, if you have a client, which I've only had this happen one time, literally one time my whole practice out of 1,000. If you have a client who says, I want to leave my property, but I don't want it to be in trust status anymore. I want it to be in fee status. Your client actually has the ability to do that in the will, okay? Your client can devise property in fee status to a lineal descendant or a co-owner, okay? Your client can do that. Now, if your client wants to do that, it needs to be clearly stated inside of the will. So if that's what your client's wanting, you put, I intend specifically for this devise to go out of trust status. I want this interest to be a fee interest, okay? The client can put those very express terms in a will, and they will be honored so long as the person who is getting the devise is a lineal descendant or a co-owner. If the testator wanted to do that in favor of the tribe or another Indian person, the testator cannot do that. The testator cannot put it in fee with that specific language. And that's just a weird kind of glitch in the statutory language that kind of keeps you from being able to take things out of trust and put them in fee. But like I said, out of 1,000 wills, I've had one client who wanted to remove the property from trust status. Okay. Okay, we talked about this a couple of times today, but for those of you who haven't been to the earlier presentations, we'll talk just really quickly that the American Indian Probate Reform Act has a presumption of joint tenancy. So when we talk about writing wills, right, imagine that your client says, I want to leave my property to my 3 kids, period, right? Under state law, right, under every probate state law in the country, if a testator says, I want to leave my property to my 3 kids, period, the presumption is that the testator left the property to the 3 kids as tenants in common. Tenants in common are people who own property, but who each have an equal undivided interest in the property, okay? So that means if you give your property as tenants in common to your 3 kids, each kid gets a 1/3 interest, and when one kid passes away, his 1/3 interest goes on down the line to his kids. When another kid passes away, her 1/3 interest goes on down the line to her kids, or however her will sets it forth. So that tenancy in common is one way you can own property, okay? And if you write a will that says, I leave my property to all 3 of my kids, period, what is going to be presumed under state law is a presumption that you meant to leave it to them in equal shares as tenants in common. That's different than AIPRA. This is something AIPRA does that nobody else does, okay? AIPRA sets forth that there is a presumption of joint tenancy. And joint tenancy is when multiple individuals own property together, but that when one passes away, whoever's left standing owns the entire parcel, okay, or the entire interest. So when we're talking about like leaving my property to my 3 kids, period, if we're looking at AIPRA, right, what that means is I leave it to my 3 kids as joint tenants, which means if one passes away, the other 2 are joint owners. When the second one passes away, the last one still surviving owns the entire interest, okay? So that difference between tenancy in common and joint tenancy is super important. But because AIPRA presumes joint tenancy, I pointed out because it's totally different than any other wills, trusts, and estates law in the country. It's totally different. No one else does it this way. So when you're writing a will that's disposing of property, if you have a client who says, I leave my property to more than one person, I leave my property to my 3 kids, just set it forth in the will. Say either as joint tenants or as tenants in common. Don't leave it open for interpretation, because if you leave it open for interpretation, it will be interpreted as joint tenancy pursuant to the statute. Okay? Make sure you do exactly what your client wants. You have to have that conversation about, do you want tenancy in common or do you want joint tenancy, and just spell it out right there in the will. Any questions about that? It's one of the things that my law students get mad at me for, because every single will, I completely freak out if it's not there. Like, just circle it in red and say, you got to put one or the other. I don't care which one, but make sure it's what your client wants, put it in there. Okay. All right. The statute itself has some provisions for spouses. I'll tell you, these are protections that you'll find in other probate codes, Oklahoma, Texas, Uniform Probate Code. This is a pretty normal approach towards surviving spouses or spouses who are left out of a will. So if a testator writes a will, and after the testator writes the will, divorces the spouse he was married to when he wrote the will, there's a presumption that that spouse should be treated as if she predeceased him. The idea is if you divorce somebody, you probably don't want them to get your property, right, after you pass away. Even if you have a will that says that they get it, you probably don't want them to get it if you've divorced them. You know, the idea is you write a will, you get divorced, you forget to go write another will, right? You never get around to writing another will. The idea is to protect people from having ex-spouses to inherit property. I will tell you, you can overcome that presumption in a will. So if you have a client who says, I don't care if I get divorced, I always want to make sure that this person is taken care of, you can put it in the will. You can say, even if I get divorced, this person still gets the property, right? You can overcome the presumption with specific language in the will, but it's got to be right there, okay? All right. If you have a situation where a person wrote a will and then after they wrote the will, they get married, that spouse can actually have protection under the act to be able to inherit, even though that spouse wasn't listed in the will because she wasn't a spouse whenever he wrote the will, okay? So a surviving spouse who was not listed in a will get the intestate share if that surviving spouse was left out of the will, and it looks like it was on accident. You can overcome that. You can overcome that presumption as well by saying something like, if I get married after the date of execution of this will, I don't want my surviving spouse to inherit anything. You can put it in the will, okay? Doesn't mean that the surviving spouse can't come in and go ahead and try to claim a forced spousal share. Surviving spouse absolutely can come in and try, okay? But it does at least help the court or the judge to understand exactly what the testator's wishes were, and they will try to give effect to testator's intent when they can. See, this is what gets so hard about this, because there are legal arguments that we can make, right? But I don't know what a judge is going to do. I never know what they're going to do. I mean, I can make arguments, but at the end of the day, a judge has a whole lot of discretion. They're going to apply the act, and the ways that the act can be applied, but they've also got some discretion there. So just keep in mind, anytime there's a contest between folks, anytime there is a disagreement between folks, the way that it hashes out oftentimes is going to be up to the discretion of the judge. Okay, if we have a situation where a testator writes a will and after the will is executed has kids, or if the testator writes a will and forgets to put a kid in, okay, there is protection for those kids who are left out. They can also come in and get an intestate share, even if the will doesn't provide for them. And that's very similar to wills, trusts, and estates law all over the country. It's very similar. You can try to overcome this presumption by including additional language. For instance, I have a lot of clients who say any children born after the date of this will should not inherit anything. I've had clients do that in their wills, right? But for the most part, people usually want to leave stuff to their kids, so they don't mind all of them sharing the same way. Thoughts or questions about that? Okay, let's talk about adopted kids. We went over this in an earlier session, but it's here again. When we talk about adopted kids, this is how it works. If the testator had a biological child and gave the child for adoption, all right, that child who was placed for adoption is not going to be considered an heir of the testator, not going to be considered a child of the testator for purposes of this act. However, if the testator adopted a child in, right, that adopted child in is going to be considered eligible as a child of the testator. Now, it is a requirement under the Act that those adopted in kids have some legally recognized decree that indicates that there's a legal adoptive relationship. And that's a little bit different for tribal communities who a lot of times have different types of adoption standards and different types of familial relationships through cultural adoption and cultural affinity. So I just want to point out, if you want this adopted child to be treated as one of your children, there needs to be some kind of legally recognized decree. It's problematic whenever you leave that up to interpretation, but at the end of the day, try to get something that looks like a valid decree in place. Now, you can overcome that, okay? I've had a couple of clients who had children that they gave for adoption. I've had a couple of clients come in and say, I placed this baby for adoption when I was younger, but I still want her to get a portion of my estate, list her in my will, and give her an equal share, just like my bio kids that I had later in life. I've had that happen a number of times, and you just do it. You can put that language in the will, and it will work, right? You need to, of course, identify the person, try to give some leads on where the person may be, but just make sure that the person's clearly identified in the will, and you can overcome this operation of the way that they treat adopted in, adopted out kids. Thoughts or questions about that? Okay. All right, so let's talk about a couple of weird formalities that are just helpful to know about, okay? There is this concept in wills law that a will is valid if it is signed, dated by the testator, okay, and then witnessed by two disinterested adult witnesses, all right? Different states have different rules about how many you have to have. Most of them say two witnesses, right? So when you talk about two adult disinterested witnesses, you need two witnesses who are over the age of 18, and you need to make sure that they're not related by blood or marriage to the testator, okay? But if you can get your client, the testator, to sign and date a will, and you can get two people who are 18 years of age older, not married, not related by blood or marriage to the testator, you get a signature from the testator, signature from those two witnesses, bam, that's a valid will. That's a valid will, okay? It is a valid will. We can use that. We lawyers can use that as a will. We can get the will through the process and get it proved up. The thing about it is, without what's called a self-proving affidavit, okay, without a self-proving affidavit, if all we have is the signature of the testator and the signature of those two witnesses, as a lawyer, what I have to do is I have to go find those two witnesses, and I have to bring them into court, and I have to have them testify about having served as witnesses to prove to the judge that they actually signed the document and functioned as witnesses, right? There's a thing you can do to keep yourself from having to go get those witnesses every time, and it's called a self-proving affidavit. These self-proving affidavits are extremely widely used in all of the states, okay? It's recognized in the Uniform Probate Code. Oklahoma, Texas has kind of a strange one, but it's a process by which you kind of certify people's identity through this affidavit so that you're not going to necessarily have to bring them in to help prove a will. So if you're used to doing any kind of wills, these self-proving affidavits, we do them all the time, right? The American Indian Probate Reform Act regulations set forth language that they want to see in a self-proving affidavit for Indian wills. And this is the language that's on your screen. It is not the same language that I use in the state of Oklahoma. It's not. My state of Oklahoma wills that don't dispose of Indian trust property have totally different self-proving affidavits because they're under the statutes of the state of Oklahoma, right? This doesn't match up with the self-proving affidavits anywhere else, but this is the one that the department wants you to use on an Indian will. I've had occasion to combine. I've had an occasion to look at both of them and see if I think one might substitute in and work for the other. But because I get so nervous about, something invalidating a will potentially, or at least, requiring this witness proving, I go ahead and use this language on any will that I have that disposes of Indian trust property. This language is right there in the regulation, okay? Basically what you do, you have your will, okay? And you have your testator's signature and your witnesses' signatures. On the very next page, you attach the self-proving affidavit, and it again is going to have the signature of the testator, the signature of the two witnesses, and what makes this self-proving is you have a notary to stamp it and sign it and verify that those people appeared in front of the notary. So that is the affidavit that you use. You append it to a validly executed will, and it releases the requirement for witness proving in court testimony. Any questions about that? Here's the second part of the language, just so you can see it. You can literally just cut and paste this right out of the regs. Right out of the regs, just use this, okay? And this is all on your jump drives too, guys, in your bags. Can we talk, we already did this in one of the other sessions, but I still am going to do it again. Can we talk about notaries just really quickly? Okay. If you guys know whenever you have a notary stamp that you can get like an ink stamp that just inks the paper? Okay. I had a will. They told me they were going to send it back and invalidate the self-proving affidavit. And actually, they were going to invalidate the will for another reason. But they were going to do so because they said that although my notary had signed the will and dated the will on the self-proving affidavit right down here, that she failed to stamp the will. Okay? But what happened was she had one of those embossing stamps. You remember those where you put the paper between the embosser and you squeeze it and it makes like a little raised seal? That was her notary seal. And whenever they made a copy of the will, you couldn't see that. So they said that she, oh my goodness, excuse me. I'm going to lose my voice. They said that she had not stamped it. So if you have someone, thank you so much. If you have someone that uses one of those embossing stamps, make sure that they shade over that embossment because then it'll show up on copies. Jim, if I lose my voice, you're in, okay? You got to get up here. So when you talk about those kind of notary issues, just remember that because I'm telling you, it causes a lot of problems. So what we do now is if anyone uses one of those embossment stamps, just get a piece of chalk or a crayon or a highlighter or a pencil, I don't care. You just shade over it because then no matter what happens, everyone can see it even if it's a photocopy, okay? So I recommend doing that if you use an embossment seal or just have everyone use stamps because you can always see those. Okay, so when we start talking about the probate process, when we start talking about the probate process, the regs that I'm citing here, I recommend that you read them because they're interesting, but the regs that I'm citing here set forth what all has to be included in a probate file for it to be forwarded on for action, and it's a whole lot of different things that have to be included. Obviously, you need a death certificate. If for some reason you live in a community that doesn't issue death certificates, there are some provisions in the probate regs here under AIPRA for demonstrating that a death has actually occurred, but for the most part, you need to be able to produce a death certificate. This slide tells you a lot more documents that have to be in a probate file for it to be considered complete and sent over for more action, okay? They obviously want originals of the wills. Now, this is what's fun, okay? They'll tell you they have to have originals. They'll tell you that they have to have originals, but their own regs say originals or copies, okay? So we argue about this. I argue about this because I say you don't need the original. Your own regs say that you'll take a copy. But I had a situation where all that was produced was a copy, okay? And the Office of Hearings and Appeals told me, if you have a copy and you don't have the original will, we assume that the testator destroyed the original will with the intent to revoke it. So unless you can show us that that did not occur, we won't accept your copy. Now, how am I supposed to prove that after my client has passed away? Because by the time I'm arguing with them about original versus copy, my client has already passed away. Do you see what I mean? So I know that the regs say originals or copies, but I'm telling you they want originals. I had a question in a session earlier about what to do in the situation where your will needs to be probated in more than one spot. For instance, if you have a probate that's going to probate the trust property, but then you also need to file a separate probate like in state court for non-trust real property, my recommendation is to take the original to the agency and let them certify a copy themselves. Let them feel and touch the original, let them go ahead and make a copy and make them certify that it is a true copy of an original, and then just make sure you can always get that original anytime you need it. State courts seem to be a little bit more lax about this and are willing to accept copies on a larger scale, in my experience, but these folks are serious about it, okay? But you see all those things that you have to include in a probate file for it to get probated? This is what we need to do, okay? When we write a will and give it to a client, we need to give the client, of course, their original will to keep in a safe place. But it's also helpful to give them a heads up that these are the kinds of things that are going to need to be pulled together, because I guarantee you the testator can get these things about his own affairs a lot easier than his wife or his kids can get them. Does that make sense? So giving people a heads up, hey, if you can keep this in a place with all your important papers and include some of these things too, just to help the process along, it might make your probate go a little faster. So it's not a bad idea to give people a heads up that they're doing this. When you execute a will, you're going to leave the original with the testator. I have a question in the back. You're going to leave the original will with the testator. And I tell you, I go through the same spiel every single time that I give an executed will to a client. I tell the client you want to keep this in a place where your executor will know where to find it, where your surviving spouse will know where to find it. Just make sure it's somewhere where people know where to find it. And you want to make sure that it won't be destroyed by fire. We live in Oklahoma, so we have a lot of tornadoes. I usually tell clients I have a fireproof safe, but I don't lock it because I would forget the combination or lose the key, right? I leave my fireproof safe in my tornado cellar, and that's where all my important papers are. It's where my will is, where my life insurance policies are. I leave it there. That's one idea, just giving clients kind of an idea of where they might expect to store something so that it can be found, because we don't have a lot of storage options from a, formal filing perspective. Yes?
I'm kind of confused on that. So on the secondary wills, how can a judge say what someone was thinking? Like, how is that a legal thing?
Yeah.
If it's documented and it's signed and notarized with two witnesses, how does that cancel out and said, okay, well, the will person destroyed it.
Yeah.
And they don't want that to be a will anymore.
I know. It's really frustrating. It's really frustrating because what I think should happen, I think instead of assuming that the testator destroyed the original with the intent to revoke, you should assume that the testator did not do that. And what you should do is wait for someone to bring you evidence that the testator, in fact, did destroy with an intent to revoke, right? Like, I think that should be a challenge rather than just an automatically presumed thing, right? Like, let someone bring a challenge and say, no, that will's not his will. He told me he revoked that. Let that happen before you just throw something out, because it's very strange. And it's hard when you look at these regs, and these regs are written in the voice as if they're talking to an individual trust beneficiary, okay? So if I'm an individual trust beneficiary and I read the regs and it says that you just need the original or a copy of my will, I'm thinking I can just give you a copy and we're going to be aces, right? So the idea that that's not really how it plays out, and the idea that there's this presumption of destruction with an intent to revoke, it's very problematic. It annoys me. I don't know how else to tell it, though. It just annoys me, and that's just where we are. We're stuck with it.
In my legal research on this issue, I did find that that's applicable in state courts also. It's not just in Indian country.
So it is. It is in some states, not in all states, right? But I'll tell you, in those instances, under like Oklahoma state law, right? Although that is available as a challenge, it's not a presumption. Does that make sense? So like a person can come in and say, wait a minute, you have a copy of a will, you can't produce the original. We want to prove to you that the original was destroyed some way. It's not just automatically presumed, but different states do it differently. Yeah. Okay, any other questions on that? So here's a whole list of stuff that needs to go in that probate file. Giving someone a heads up that this is what folks are going to be looking for, maybe they'll get some of it together before they pass away. Yes?
Do you know at all if those same presumptions are held at other branches of the agency? I mean, is it
Yeah.
just adjudicated that way in your district, or is it
That's the standard,
that they're applying?
that's right,
Across the
that's
board?
right. And it actually comes out of an IBIA case. It comes out of an IBIA
Okay.
case. Yep.
But it's not in the regulations
No.
anywhere?
The regulations say
that
copies.
Say this, but
Yep.
they say, okay.
Yep. But don't get mad at me, I didn't write it, okay, okay, okay. All right, so the rest of these slides really talk about more on the probate process side, and I'd really like to just point you to the area in those regulations where you can learn more about how the probate works. It's all through that administrative process, and if you have questions about how it works, those regs really do give you a step-by-step kind of encounter about how it's going to work. I will say, from the probate perspective, there are a whole lot of probates. They do cost quite a bit of money to get done on an individual basis, and it is extremely problematic to try to get them all caught up because there's always such a backlog. But I'll point you to those slides that are on your jump drive and also to the regs. I wanted to give Jim some time to talk a little bit about the electronic wills project that the Indian Land Tenure Foundation is working on. Like we talked about at the beginning, I want you to be very careful about not practicing law without a license, about not doing anything unlawful under your state's law. But there are these mechanisms to empower individual landowners to draft their own wills, which is entirely fine, okay? And Jim's going to talk to you a little bit about that project. Do you have any slides for that?
I have the stuff in the background.
Okay. Well, then I'm going to get out of that. Okay, there you go. I'll do this.
Good afternoon. Thank you for this opportunity. The Indian Land Tenure Foundation has been working at getting wills written for Indian landowners going back all the way to the passage of AIPRA and back in 2004, and with strong efforts from 2006 through today. We still have funding. I think I would say that the foundation probably has used about $5 or $6 million of our own resources over time to get wills written for Indian landowners, and we've probably had about another $6 or $8 million from the federal government, both through the Office of Special Trustee and Bureau of Indian Affairs, to do wills for Indian landowners, because the Interior as well as the foundation recognize the importance of landowners exercising their rights and not letting an administrative law judge determine what happens to their land. It's an exercise that allows you to take ownership over your land and use it in a way that will help you realize the goals. With that in mind, we were trying to find a way to make it much easier for landowners to get the will drafted. Sometimes going and meeting with an attorney can be expensive. That's something that keeps landowners from doing it. There are free options if you're income qualified. The foundation certainly does not put restrictions when we do not have to on who can access those services. We have used the Wills Clinic at Oklahoma City University going back to 2014 to get wills written as part of our projects. We then used an Administration for Native Americans grant to create and design a will that can be used pro se. Pro se means that the landowner is doing it for themselves. I don't forget the exact legal Latin definition of pro se, but it just means they're doing it themselves. In going through that process, we were able to create this interview that I'll go through and show you real quick. I had Brenda pass out the will that comes from this interview so you can kind of see how this shapes up after you've done the process. After creating this for Minnesota, we worked with the Montana Legal Service Association. They wrote a grant to the Legal Service Corporation to adapt this into multiple states. And so we have it now so that it will work with Minnesota, Montana, Oklahoma, and Wisconsin. And by working in those states, what I'm explicitly saying is that in those states, it captures the nuances that Casey was referring to under state law for non-trust assets. It does not work in those states even for land that is on reservations with their own probate codes. So as you go in, what you would do is pick a state. We did put in disclaimers so that landowners, as they're looking at this, have an idea of what issues are important to understand, what data or information they'll need to collect before beginning the process. Because what we're hoping to accomplish with this project is that more Indian wills get written and submitted so that it takes care of land ownership according to what the landowners would like to do. So let's see. There are 14 federally recognized probate statutes or codes, and I differentiate statutes as those who have congressionally passed laws that dictate what happens for their probate process. Specifically, some of the Columbia River Valley folks up in the Pacific Northwest, some of the Lakota communities in North and South Dakota, as well as 5 Tribe. This list actually kind of breaks out some of the others that fall under that. There are also 3 tribes who have federally recognized probate codes resulting from their activities using the American Indian Probate Reform Act. So those are probate codes that pretty much follow what is in AIPRA, but it is adapted specifically to what the tribe would like to see. For instance, the Fond du Lac Code from here in Minnesota, they address issues of non-trust personality, such as funerary objects and traditional customary items, as well as cash benefits that might accrue to a spouse or to family members. But for purposes, we'll kind of keep trucking along. As the interview goes through, we try and track down where you're at, where you're enrolled. It goes through and it will collect personal information of you, your spouse if you're married, any children you might have. And then it goes through the different things. Again, as an intake tool, I could see this being used in an academic setting, such as a wills clinic with or wills and estates class at university, so that as students are learning these processes, they can go through this and see what a will looks like in the end. It's a dangerous thing to look at the practice of law, but I could also see making this available to tribal land professionals so that when you have a landowner who comes into your office trying to figure out what to do, you can suggest that they take a look at this, perhaps even going so far as to getting the resultant will and taking it to the tribal attorney. If your tribal community makes attorney services available to your citizens, it certainly makes it much easier for the attorney to meet with more clients, more landowners, if a lot of it's already been taken care of ahead of time through this intake process. And so it designates personal representatives, or as Casey was referring to them, the executors of your process, of your probate. If you decide to choose a burial agent, it does include that information. And it does allow for exclusions. So as Casey was saying, if you have a problem child who's maybe fallen into the bottle, you could certainly exclude them from the process because, as far as you're concerned, the bottle or drugs and alcohol may have taken them over, and you're not able to feel that they're going to benefit from your trust assets or your non-trust assets. So as we go through property distribution, gives you the ability to enter specific non-trust and personal items. As we go through this section, as you can see, it's got the different pieces. Some of the interesting things that we decided to make sure were available so that it clarified as per stirpes and who survived me, very specific legal terms. As this gets continued to update, we are going to be adding per capita at each generation, which is another form of distribution. Let's see. So you can see the difference between per stirpes means that if your child predeceases you, your grandkids will get theirs divided equally. If they do who survived me, or actually per capita each generation, what it will do is actually elevate your grandkids to the same level as your actual kids, and it gets split. So if you have per capita at each generation with 3 kids, one of whom predeceases you who has 2 kids, now instead of it being divided by 3, it's actually going to be divided by 4, because the 2 grandkids will actually get an equal share vis-a-vis your own kids. But let me see. Like I said, so the hardest part in going through this way, the heck. Dang it, all right. It's saying I missed something, but seeing as I actually completed this a couple of days ago, I don't know why it's deciding to fight me. That's okay, I know how it's built, I can just skip that. Let's see. Well, because we haven't gotten to trust property. Well, no, that's special gifts. Non-trust. Well, it's not germane to our discussion, but you get an idea of how this thing is built. It walks you through the process so that at the end, you'll get instructions. So as you look at the handout, you can see what the will looks like. In a standardized format, that means that how each of those sections is addressed, how they get presented is the same in our will for all 4 states. The standardization process also addresses the question that happened in one of the earlier conversations about AIPRA compliant wills. Do you write 2 wills, one for state court, one for tribal purposes? This one puts it all into one document. Casey had mentioned that there is an advantage perhaps to having 2 original wills, one that gets used in the state system, one that gets used in the federal system, but it does also pose a lot of probably more serious problems longer term to have 2 separate wills. And so in working with our attorneys, and I am not an attorney, by the way, our attorneys had suggested, yes, one consolidated will that addresses all of this is most efficient and effective. The nice thing, too, is that we included the information about what to do with a will, how to store it. I know in some of my will writing presentations, I will refer to the fact that storage, not storage, at the bank, what is that? That's safe deposit box, thank you. A safe deposit box can be a very good place to keep the will, but should you make that decision, make sure that your executor is also going to have access to that as a named party. It would be awful to have your will in a place that's going to take time to go get. The other thing that we also recommend that doesn't show up in here is to, if you have your burial instructions, don't put them in a sealed envelope with your will, because obviously they're going to need those much sooner than the will itself. Like I said, this is a project that I think holds a lot of long-term value to Indian country so that we can get wills written. And looking through how this process is laid out and going through the handout, do you guys have questions about what we're trying to accomplish? Or suggestions that you would like to see us put into place?
I have a question about how the information is secured after the will is printed. Does this remain on a server, and how is that server protected so that the information can't get hacked?
That's a good question. I don't have a good quality answer for that. One of the things I had skipped at the beginning, because I had this saved, is you can create a login so that it is saved on the server. You could also do this by just getting started and not creating an account. The disadvantage to not creating an account is you have to finish it all in one sitting, at which point the information isn't necessarily going to be saved on a network in some place in cyberspace. If you do create an account, it allows you to do it in multiple sittings, but at that point, the data is captured on this server. This server is Law Help Interactive, which is maintained and operated by the Legal Service Corporation, a national organization. At that point, I'm not sure how much I could say about how safe and secure it is. If security is an issue for your clients or for you as a landowner, this might not be the right product for you. Like I said, it's a good question, and I will take it back, and we will make sure to continue looking at that issue, because I do understand that it's not just you suggesting this. This is probably a much bigger issue, but it hadn't come up to date in our testing. Thank you.
Could this be used in states not listed? I saw there's a box for other state, or would, in that instance, you think a separate will be necessary for non-trust property, or?
Well, this is a
Maybe.
development process. As I mentioned, we originally created this in Minnesota. To take it to Oklahoma, I had to submit to Casey and find out what are the specific changes under state law, and that's a process to go through with the legal team. With the legal team's feedback, it takes time to go to the developer and make these changes. So as we're looking at tribes in Oklahoma who are not AIPRA compliant tribes, they have their own probate laws. We did not cover them because it would take as much effort. So for instance, here in Minnesota, Fond du Lac is an excluded tribe. Fond du Lac is excluded because it would take as many resources, financial, time, and otherwise, to create something for Fond du Lac as one single tribe as it would for the other, was it 16 or 17 here in Minnesota? As we go to, say, South Dakota, we would end up with 3 or 4 more, or the exclusions are actually already in here. And so those would cover the state of South Dakota, not for those tribal communities. At some point, we'd like to see this for all states that have tribal land, and eventually for all tribes that have their own probate code. So I've had conversations with Casey about what we can do to make this 5-tribe compliant. Osage, unfortunately, is probably going to be one of the last ones we tackle in Oklahoma, because it's one tribe with its own specific piece.
Curious, I'm from Washington State, and there were Washington State tribes on your
sure.
exclusion list, but Washington State was not on your inclusion list?
Well,
Like, it
and
wasn't one of
again,
the states
because we
listed.
haven't gotten to Washington
Yeah.
yet.
Okay.
Well, and also you may have people who are citizens of tribes in Washington who live in Minnesota. Do you see what I mean? So
Yeah,
you don't want to
yeah.
kick them out of the interface because, there may be an ability to effectuate what they want that's compliant with Minnesota law.
Well, and
But-
that's a common thing. And in Washington, I have relatives with land interests in other states. And, I mean, I guess that's a whole separate issue, maybe.
I would just caution against using this for any state that hasn't been developed, just because every single state has their own probate code and their own specific state-specific requirements. I think if you wanted to use it as a starting point and then take it to a licensed attorney in that state to make sure it complies with that state-specific laws, right, that you'd be fine. But I would caution against unveiling it for use by a pro se client until it's developed
Till
for
it's
that state.
developed.
Yep.
Yes, in fact, for the state of Minnesota, when we created it, it has a codified uniform transfer to minors law for Minnesota. Well, as soon as I show up in Oklahoma, we're like, oh, we don't have anything like that. Yeah, it's different, so I had to strike things. And each state kind of has its own nuances. When we're looking at, in your packet, you'll see that there is the ability to add property, both personal, I think just personality, after the fact. And there's a blank form that you could use. Well, when I'm doing this in Oklahoma, anything that's included in the will has to be before the signature lines. So if you're going to add property after the will is written, well, Casey would make you rewrite the whole will, and that's the wisest course of action. But legally speaking, you could use a codicil, which fulfills most of, in fact, actually all of the same things that a will would require, but it's done after the fact, and it references the original will with date, name, and all of the information to show that it is intended to be part of and not replacement for the actual will.
Would disposal of out-of-state property require separate wills to be compliant with the laws in that state? Or
For
would
for
intestate
realty?
process just go through one process, even if there's land in other states?
Well, are you talking trust land or non-trust land?
Both.
Well, for non-trust land, yes, it would have to be compliant with property rules in those states. Again, because we only addressed Indian land that is AIPRA compliant. AIPRA is federal. It's uniform across all of Indian country except those exclusions. So as somebody who's part of the Columbia River family, as it were, you could have land in Idaho as well as Washington and maybe even Oregon as well.
And all in the same document.
And it could go in the same document because the tribes that we include are AIPRA compliant. So for instance, Confederated Tribes of Umatilla excluded, Yakima excluded, because they all have tribal specific pieces.
But realize that that's different for AIPRA than it is for non-trust property.
Yes.
So if you own non-trust property in multiple states, you only need one will, but you need to comply with the will requirements of the state where you're a resident, regardless of what the will requirements would be for property that's in a different state. So you do actually end up having to go probate that land in the other state under an ancillary probate action, but as long as your will was valid in your resident state, they'll follow the terms of that will in a foreign state through an ancillary probate. It's crazy.
And as we're trying to approach this as a pro se, non-attorney will, it does only address simple processes. As you get more complicated, I personally would recommend you go talk to an attorney. If you're in multiple states, get an attorney. Absolutely. I mean, even as a real estate professional, I had real estate sales licenses. I could have sold this stuff without, but I had to set aside time. I'd have to set aside the energy. It's much easier to pay the professionals who do this on a regular basis, and it gets taken care of correctly and timely. In this case, you don't want to screw something up. So I would certainly say complicated, go to an attorney. It's 4:30. Any questions, or are you looking to get the heck out of here? Well, thank you very much. I appreciate your audience. and this
Thank you,
opportunity to share it.
everyone. And again, I'll have the MCLE sign-up sheet on this front table here. Don't forget to do your evaluations.